Your Honor, Mr. Williams is here for a pretrial. He has come to a resolution with Mr. Stiller and Ms. Coons. He's going to plead at a count of operating while visibly impaired.
That's correct.
Okay. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Martell Williams.
Sir, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 93 days in jail, up to a $300 fine plus court cost. The court could order any rehabilitative services or community service the court deems necessary. Court could also order your vehicle immobilized. Court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Understand.
Understanding that, still wish to plead guilty?
Yes.
May 25th, 2023, at the location of Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had like a beer and a half the night before and like a 12 ounce when I woke up.
Okay.
Inside a tense courtroom, Mr. Williams finds himself standing at a critical turning point. The judge has laid out the options, and in front of him sits a plea deal that could alter the rest of his future. The offer: plead guilty to operating while visibly impaired. But this isn't a minor traffic ticket or a light penalty. On the line is up to 93 days in jail, a $300 fine, and the added requirement of completing mandatory rehabilitation programs. The air is heavy with tension, and every pause from the bench feels like it carries the weight of a verdict. The judge's words are deliberate, sharp, and unyielding, making it clear this is no ordinary decision. This moment isn't only about Mr. Williams, but about the harsh and unrelenting reality of the justice system itself. In here, choices echo. A guilty plea may mean structure and reform, but it also guarantees punishment. The courtroom watches closely. Was this simply a bad decision that led to being stopped by police, or is it a larger pattern of behavior finally catching up with him? The answer will shape not only his sentence but his path forward, whether he leaves with the chance to rebuild or finds himself deeper in the grip of the law.
Were you stopped by the police or was there an accident?
No, I was just pulling over because of the construction that they had. So when I was sitting there, the police just came up and was asking me what was going on.
Okay. You're not disputing the right of the police to stop you in this instance? Okay. Were you ultimately arrested?
Yes.
Were you taken to the hospital?
Hospital, yes.
Okay, was there a blood draw? What were the results of that blood draw?
I never seen the results, but after that, I came here.
Okay. If I told you it were 0.186, counsel, would you stipulate to that?
We would, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
I don't think it was, but...
Well...
You don't want to plead guilty?
Oh yeah, I do want to plead guilty, but I wasn't like drunk or nothing. But, you know.
The truth begins to unravel under the pressure of the hearing. With the judge pressing for clarity, Mr. Williams admits he had been drinking beer the night before, and another one that very morning. He wasn't even pulled over in a typical traffic stop. In fact, he had pulled over on his own. But fate intervened. Patrol lights soon filled his rear view, and an ordinary stop quickly turned into a life-changing moment. A blood test followed, and while Mr. Williams never saw the paperwork, the court did. The result was undeniable. **0.086***. The number echoed in silence across the room. It didn't murmur. It thundered. In that instant, his defense didn't just weaken, it collapsed entirely. The weight of reality hit the courtroom like a freight train. No arguments left to hide behind, no excuses strong enough to erase the evidence. In that single moment, the case shifted from possibility to inevitability, and everyone present felt the impact.
You're a 0.186. So you think that
I don't know.
you could, hold on a second, you're a 0.186. And so if you were operating that motor vehicle, you don't think others would have noticed that you were impaired?
Well, probably yes.
Okay, so I'll ask the question.
Coming from the police, yes.
Yeah, okay, so let me ask the question again. Taking everything into consideration, on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel.
I'm supposed to do that tomorrow at 1:00 over the phone.
Where?
On the phone at 1:00.
What?
The assessment.
Okay.
With care.
It's through Washington County.
Mr. Williams clings to the same refrain. I wasn't drunk. But the law isn't built on how he felt *. It's built on how he appeared * and how his actions measured against the standard of impairment. The judge leans in with a pointed question. * would others who saw you believe you were impaired? * the silence that follows is heavy. Finally, with hesitation, he concedes, probably yes. In that moment, denial gives way to reluctant truth. The courtroom feels the shift as the guilty plea is entered. One count is dismissed, but accountability remains. The gavel falls with a sharp strike, signaling not an ending, but a turning point. The sentence unfolds. Mandatory alcohol screening, participation in a victim impact panel, and the weight of knowing his choices nearly cost more than just his freedom. Justice here isn't only about punishment, it's about reflection. A forced reckoning with the dangers of impaired driving. For Mr. Williams, the road forward will be sobering in every sense of the word.
Do you have another pending case?
No, my probation officer,
So,
well, Mr. Coons knows this already. But
So somebody's giving him another assessment, so.
okay.
Sentencing in this matter, April 10th, 2024, 9 a.m., or as your invite indicates.
Before you give away the file, Your Honor, there's a bench warrant in the file for a bond violation.
There it is.
For another violation, Mr. Williams and Ms. Coons did speak of it, about it. They would like to set it for a hearing. He does deny the allegation of consuming alcohol at this time.
The two. He wants all of that set. He wants it set for a hearing?
Yeah.
I'm in room to dismiss it.
The bond violation?
He says.
Yeah. Well, I'll tell you what.
Then, just when it seems the case is winding down, boom, a curveball. A bench warrant is issued, accusing Mr. Williams of breaking the very bond conditions meant to keep him sober. The allegation? He's been drinking again, but this time, he doesn't fold. Instead, he rises with a burst of defiance, insisting the test got it wrong. His explanation echoes through the courtroom. It wasn't alcohol, he claims, it was hair conditioner. Yes, hair conditioner containing alcohol. The courtroom stirs at the bizarre defense. What was meant to be a safeguard now becomes the centerpiece of a heated dispute. It's not just denial, it's a desperate swing at the system, one last attempt to punch holes in the evidence. And instead of dismissing him outright, the judge acknowledges his demand. A hearing will be set. The battle isn't over. The next chapter promises a clash where details matter, where science and fact will be tested against a claim as slippery as the truth itself. The question now, will this defense hold, or will it unravel under the weight of scrutiny?
Does he really want to do that?
I don't want to get into it necessarily, but I mean, the level was very low. He thinks that there was another reason of
Oh boy.
why it detected alcohol. It was a
Much like not being visibly impaired.
hair product, yes.
Because when I got
Oh, really?
when I got released from jail on the 7th of last month, I got my hair.
Okay, what kind of hair product?
When I read the bottle afterwards,
Yeah, I know. What kind of hair product?
conditioner.
Conditioner? So that had alcohol in it. A lot of alcohol.
Whatever.
So hold on. It had a lot of alcohol in it. Is that what you're telling me?
That's all it could be because they told me to
Really?
change
Okay.
my,
So
product.
I'm going to say this. I kind of know about your hair. Just saying. And if you put too much alcohol on it, other things happen.
And just when the case seems like it can't get any stranger, Williams digs in deeper. He insists the alcohol detected in his system didn't come from drinking at all. It came from a hair product. Yes, you heard that right. Hair gel with alcohol. The explanation draws curious looks around the courtroom. The judge leans forward, eyebrow raised. It's true that many products contain alcohol, but could something as simple as gel or conditioner really trigger a test result strong enough to suggest drinking? The judge turns to the report. Blood work. Clean. But hair samples? They are lighting up with alcohol markers. What follows is less like a standard hearing and more like a collision of science and suspicion. The claim isn't dismissed outright, but neither is it accepted. Williams pushes for a hearing to prove his point, and the judge grants it. Now, the courtroom is poised to transform into something more than a place of law. It becomes a laboratory of truth. The coming battle will pit technical evidence against unusual explanations, and the outcome could determine whether Williams walks free or digs himself even deeper.
Like you don't have hair, because it will break off and fall out. So I'm looking at these numbers here, and yeah, they're low for the human body, high for hair.
Well, Your Honor,
No, I want to have a hearing.
if you would like to,
No. You've asked for one.
I do.
I'm just here. I am here to serve.
I did hear Mr. Stiller say he'd be willing to dismiss.
I know, but I'm not.
Okay. Then we will hold the hearing.
Yes, we'll have a hearing. Give me a date. I need a date before April 10th so that the findings of the hearing can be taken into account at sentencing. Let's do it. Let's do it on trial week at the end of this month.
Okay.
What day?
We can do Wednesday, March 27th at 1 p.m.
Okay. So bond violation hearing on hair product